Let's go ahead and get started. First of all, I want to thank Professor Prakash and Professor Yu for joining us today. We really appreciate it for giving us their time for this debate today. I would also like to thank everyone who's here today and remind you that if you would like to join the Federalist Society, we would love to have you. If you join on our website, fedsoc.org, it gives you access to webinars like this, events at other schools. It gives you access to national events like the National Lawyers Convention and the Student Symposium, which will be held in March, and that will also include 50% to potentially 100% travel voucher for that event as well. I can tell you from my own personal experience, both of my internships, I've gotten them through FedSoc connections, and it's been a wonderful opportunity. I've also been able to participate as one of the summer editors for the Harvard Journal. If you are a member of the national organization, you're able to participate in that as well. And we've consistently had George Mason editors, and we would love to keep up that tradition. I'm going to hand it off to Chris in a moment to introduce our speakers with their bios. Just a word about asking questions for this debate. We would love to have your input. Please do not use the chat function. It's a little confusing. Please use the question and answer feature, and I'll be able to answer questions at the end of today's event with that. And with that, Chris, thank you again to our professors. You can go ahead and read the bios.
Thank you, Sydney. Professor Yu is the Emanuel Heller Professor of Law at the University of California at Berkeley. He has been a visiting professor at Seoul National University, Trento University, the University of Chicago, and the Free University of Amsterdam. Professor Yu has served in all three branches of government. He was an official in the U.S. Department of Justice, where he worked on national security and terrorism issues after the September 11th attacks. He also served as General Counsel of the U.S. Senate Judiciary Committee under Chairman Orrin Hatch. He has also been a law clerk for Supreme Court Justice Clarence Thomas and Federal Appeals Judge Lawrence Silberman. Professor Yu has published almost 100 scholarly articles on subjects including national security, constitutional law, international law, and the Supreme Court. His latest book is Defender-in-Chief, Donald Trump's Fight for Presidential Power. Professor Yu graduated from Yale Law School and summa cum laude from Harvard College. Professor Prakash teaches constitutional law, foreign relations law, and presidential powers at the University of Virginia Law School. Professor Prakash majored in economics and political science at Stanford University. At Yale Law School, he served as senior editor of the Yale Law Journal and received the John M. Olin Fellowship in Law, Economics, and Public Policy. He subsequently clerked for Judge Lawrence H. Silberman of the U.S. Court of Appeals for the District of Columbia Circuit and for Justice Clarence Thomas of the U.S. Supreme Court. Professor Prakash is currently a Miller Center Senior Fellow and has been a visiting professor at the University of Illinois College of Law, Northwestern University, and the University of Chicago. He has also served as a James Madison Fellow at Princeton University and a visiting research fellow at the Hoover Institution of War and Peace at Stanford University. Professor Prakash has authored over 75 law review articles. His most recent book, The Living Presidency, an originalist argument against its ever-expanding powers, was published by Harvard Belknap Press in 2020. Professors.
Excuse me. Thanks, Christopher, for that introduction, and thanks to Sydney for inviting us to join you all today. It's great to be here with you virtually. I think I last was a Mason 2 years ago doing a talk with my co-author, Jeremy Radkin, a book about high technology and the rules for war. But I didn't like writing with Jeremy because he made me work way too hard. It was punishing. So instead, I wrote this book all by myself. Now, I know Jeremy agrees with every word in that book, so I didn't really need him as a co-author. The other thing that's great is, look what they gave me when I was there last time. I have one of the rare, I hear these are not available. So to the person who buys the most copies of my book after this event, you can have this hat. I will send it to you if Sydney tells me. But actually, I'm never going to give this up. I love this hat. This is a unique collector's item. So I'm here not necessarily to praise or to bury President Trump, but to describe how a president who 4 years ago, who everyone feared would be a great disruptor of the Constitution, became, in my view, its unlikely defender. And the reason why is because, to start with, 4 years ago, President Trump came in as a populist, and populists always arrive in Washington saying they have a popular mandate to overthrow the way we do business, and to overthrow the status quo. And the status quo is usually represented by the Constitution. But a funny thing happened over the last 4 years. Instead of Trump, I think it's his opponents who became the greater threat to the Constitution and are even now contemplating far more radical changes to our constitutional order than anything Trump did. In fact, I'd say Trump used traditional arguments about the presidency and relied on the same practices of his predecessors and looked to the constitutional text and structure more to defend himself from people who are attacking the legitimacy of his election for the last 4 years. So let me give some examples. Right now we're fighting about the Electoral College, and I think it's an interesting example of how determined the founders were to prevent Congress from controlling the independence of the executive, of reducing the energy and the decisiveness of the executive, ability to act with speed and secrecy and decision, in the words of Alexander Hamilton. And one of the ways they try to do that is what we're going through right now. They vested the election of the president in the states, or it's the state legislatures that actually pick the presidential electors. Now, the states have chosen to delegate that power to popular election in their states, but under the Constitution, it was still given to the states to decide, with, of course, the strongest weight to popular views because of the way the electoral votes were allocated. Meanwhile, it's Trump's critics who are proposing to get rid of the Electoral College and are pushing something called the National Popular Vote Initiative, whereby states would commit to giving their electoral votes to whoever wins the national election. Here's another example. Look at the Supreme Court. We had a vacancy just in the last year. Every president, including Donald Trump, has nominated a Supreme Court justice when a vacancy has arisen. There's no great constitutional affront to doing so. In fact, it's really a question of the Senate and its procedures and precedents, whether it wants to confirm a justice to a seat that opens in the last year of a presidential term. And it's been the case that presidents have had their nominees confirmed almost every time when the Senate has been controlled by the same party in that last year. And I think the figures are less than half of the nominees have been confirmed when the different parties control the president and the Senate. To have a rule that says no nominees can be confirmed in the last year would have deprived us of people like Chief Justice John Marshall, who was nominated and confirmed in the after the 1800 election had taken place, and justices like Brandeis and Cardozo, some of the greatest judges in American history. What's the response to that? I think a terrible overreaction. The idea that a Democratic president with a Democratic Senate and House would first get rid of the filibuster and then pack the Supreme Court, increase its size from 9 to 15 justices, essentially increasing it by 2/3 in size. Now, that's certainly, as you all know, having been to law school now, within Congress's power to change the size of the Supreme Court, but to do it because we don't like the answers the court is giving us on constitutional questions, I think threatens to launch a escalation where each party will just keep increasing the size of the court when they take power. And ultimately, the courts become something more like administrative agencies that pursue an agenda of the elected party rather than a neutral institution that's supposed to call the balls and strikes, in John Roberts' words, on constitutional questions of the day, and might be subject to ideological differences, but not necessarily partisan political ones. It's not Trump, it's his opponents who want to create a permanent independent counsel that would use the power of prosecution and criminal laws to examine our policy fights. I'm curious to see actually whether President Biden and his supporters are going to stay true to that promise now that they have won the presidency. It's not President Trump, it's his critics who want to nationalize large parts of the energy sector, housing, and transportation sectors with a Green New Deal. I think vastly expanding the size of the federal government beyond what I think was originally intended by the founders. In the meantime, I think President Trump, for all his rhetoric and all the crazy things he says on Twitter, has not really tried to undermine or destroy the Constitution, no matter, despite the things one hears in the media and on the nation's op-ed pages. Take what's going on right now with the recount. If you had read the newspapers leading up to the election, you might have thought President Trump was going to launch the military into cities and try to create sufficient unrest to undo the results of an election. Instead, President Trump, I think it's futile in the end, but I think President Trump is pursuing his legal avenues, which are quite legitimate, to ask for recounts, ask for validation of the votes, but he's not trying to do anything outside the bounds to try to legally question the outcome of the election. And more importantly, look at the two major crises of his time in office, the Russia collusion investigation and the impeachment crisis. In both cases, I'd say what he did was he used the Constitution as a shield to defend himself, and more importantly, sought to reach back to an 18th century conception of the presidency and of the Constitution, and to use it to fight against what I think of as a 20th century progressive view of the Constitution. That 18th century view is the idea that we the people elect officials who serve in government, and they are directly accountable and responsible to us, and those officials are therefore in charge of the great powers of government. The progressive view, which I think he's fighting, has been fighting in these contests, is the idea, I think, really introduced into our politics by Woodrow Wilson in a serious way, and then really firmly established by FDR, and then dramatically expanded by Lyndon Johnson. And that's the idea that public policy questions are too important for politicians. Instead of having elected officials decide major questions, we should delegate them to experts. And we should insulate those experts as much as possible from politics. You see that in both the impeachment and the Russia collusion fight. With Russia collusion, remember, it's all triggered by President Trump firing Jim Comey, the director of the FBI. You would have thought this was some great constitutional sin if you listened to the media. But under the Constitution, the president is the only officer constitutionally charged with the responsibility to take care the laws are faithfully executed. All the people who work in that area, in the law enforcement area, are his or her assistants. And here he must have the power to remove them in order to control the policy. President Trump tried to make sure that the Justice Department and law enforcement reported directly to him. And if we don't like the way he does it, then we can hold him accountable either through impeachment or through the election, which is maybe what's been happening right now. But it was the idea that the FBI and our national security bureaucracy is somehow independent from political control. That was a threat, I think, to the Constitution. Look, impeachment's very similar. Here you had a bureaucracy, the Foreign Service, that thought that it was independent of presidential control, that they should set what the national interest was through the interagency process we kept hearing about, and that they should be in charge of how diplomacy was to be conducted. Meanwhile, President Trump, I think he had unorthodox foreign policy views and certainly unorthodox ideas about how to pursue foreign policy. But under the Constitution, the president, as the bearer of the executive power, has long been understood to hold the power to control our foreign policy. And it's up to him, not the Foreign Service, to decide what the nation's goals are and how to conduct them. I think Cy and I agree about a lot of that. I think where we're going to disagree are more complicated questions like the power to declare war, where I think President Trump, like his predecessors, has asserted the authority to use force without a declaration of war. I happen to think Congress, if it wants to stop wars, can use the funding power or its power over raising the military, but that the fight over war is not one over control about who starts it in the way we pass a statute, which is the way I think most scholars on the other side think of it, where Congress sets the policy and the declaration, the president carries it out. I think instead, and this goes back then to the final, the theory underlying my book, instead the founders expected that the president and the Congress and the judiciary would use their constitutional powers to fight for policies for dominance, and that their constant struggle in pursuing their self-interest is what would be the real check on the federal government and on each branch. And so I'd say that's why I think in the end, President Trump has been a defender of the Constitution, because by pursuing his interests, pursuing the interests of his branch, he is actually living up to the model that the founders have about how they thought the separation of powers would work. So thanks very much for bearing with me, and I look forward to hearing from Cy and look forward to hearing from all of you. Thanks.
Well, it's great to be here with you folks. It's great to be associated with the Antonin Scalia Law School. Of course, Justice Scalia was a great justice and a great patriot, which is appropriate given your school mascot. And I just sort of realized that John, having served in all three branches, is like John Marshall. John Marshall also served in all three branches. So John and John are
I'm much smarter than he was.
Of course, that goes without saying, John. So I'm delighted to be here to talk to you about the presidency. And here are the books. Here's John's book, Defender in Chief. If you go online, you can see a picture of John with the president, and John's holding up the book and the president is smiling. Better times for the president. And then here's my book, The Living Presidency. Both are available at fine bookstores, and both are available at Amazon, whether or not you consider it a fine bookstore. John's book focuses on President Trump. Mine does not. I say very little about President Trump. And I did that by design. I didn't want a book focused on the controversies of the day. And of course, there have been quite a few controversies. I wanted to sort of step back and think about what the presidency had become over time, what it was at the founding and what it has become over time. And the basic thesis of the book is that we have a living presidency. We have a presidency that expands over time into new areas, usurping congressional power, and in some cases even trenching upon private right. And I think to really understand this, you have to go back to the founding. And at the founding in 1787 through 89, they created a presidency that was going to be quite powerful. Make no mistake, the presidency wasn't designed to be weak. People who say that are reading it, reading the Constitution anachronistically as if it were written in 1776. In 1776, there was a severe jealousy of executive power that led to the creation of weak state executives. But by 1787, many people understood or came to the conclusion that weak executives were part of the problem. Weak executives could not stand up to powerful legislatures, and therefore there was an imbalance in the separation of powers. Legislatures were too strong, the courts and the executive were too weak. And so there's this consensus forming in 1787 that leads to the creation of a super strong executive. And another reason for a strong president is that everyone thinks that George Washington is going to be the first president. And so that naturally leads some people to let down their guard. So the presidency is designed to be very, very strong, but there are limits, right, to the office. It's not all powerful. What are those limits? Well, the president has to take care that the laws be faithfully executed. The president can recommend measures. The president can veto. This all implies that the president can't make law on his own and that he can't twist existing statutes to serve either his personal ends or even public policy ends, right? He's got to faithfully execute the laws, not twist them to achieve other purposes. Second, the president can only make treaties with the advice and consent of the Senate, 2/3 of the Senate. This is an extraordinarily high threshold, and it's designed to ensure that the rights of states are respected in the treaty process. That is to say, states are worried that their authority is going to be trenched upon by treaties, but also that territory or other rights might be given away to foreign countries, and they want to check on that. And the check comes in the form of this 2/3 requirements. And remember, back then, senators were appointed by the legislatures and were likely seen as, in some sense, agents of those legislatures and perhaps apt to protect state sovereignty. The third feature was that the president could not declare war. Everybody understands that because the Constitution grants it to Congress. But the question is, what does it mean to declare war? And as John noted, I disagree with his claim. In the 18th century, to declare war was in part to decide to wage it. And if you waged war, you had in fact declared it. That is to say, a nation that launched attacks on another nation had, by the very fact of the attack, declared war. How do we know this? Because it was quite common in the 18th century to say that nations had declared war via attacks. And in fact, most wars were declared via attacks rather than by some piece of paper or some missive sent to a foreign court. And that's why the British Prime Minister said, of late, most of our wars have been declared from the mouths of cannons, and our next war will no doubt be declared from the mouth of a cannon. And that's why John Adams was able to tell his cousin Sam Adams, England and France have declared war against each other during the Revolutionary War, even though neither had issued a formal declaration of war. And in fact, these actions that constituted declarations of war were said to be the strongest declaration of war because they evinced unmistakably that the nation had decided to wage war against a foreign country. So with that understanding of what it means to declare war, people in the 18th century, the late 18th century, the people who ratified and wrote the Constitution and the people who read it afterwards came to the sensible conclusion that presidents could not start wars because if they did, they would be declaring war, right? The only way we can declare war in the United States is by this cumbersome process of bicamerals and presentment, right? Congress has to pass a bill, the president has to sign it, or they have to overcome his objections by overriding his veto. If the president takes us to war, he is essentially usurping Congress's power to declare war. And that's why many people at the founding said it's not within the power of any one man to take us to war. You've got to go through this sort of complicated process. And that's why people like Washington, Jefferson, Adams, Hamilton, Madison all said that the president could not wage war. So flash forward to today, and we see a radically different environment with respect to presidential power. With respect to war powers in particular, everyone knows about the Korean War and what's happened since then. Essentially, presidents have taken the nation to war through military acts overseas, and they justify it not by reference to a reading of declare war, but they justify it by reference to past practice. They say practice has put a gloss on the Constitution, citing Frankfurt's opinion in the Youngstown Steel Caesar case. And so they're not making a claim about the original Constitution. John is, but they're not, right? They're not making that sort of claim. They're relying upon practice. What about treaties? Well, we don't make any treaties anymore pursuant to Article 2. We make treaties by other means. Let me give you two ways we make treaties by other means. First, presidents now make sole executive agreements with respect to the type of agreements that would have been done by treaty in the past. That is to say, presidents make treaties, call them sole executive agreements, and bypass the Senate. So the category of executive agreements that can be done outside the Senate has expanded over time to encompass things that would have been done by treaty in the past. But maybe sort of more obviously, the president now makes treaties by and with the advice and consent of Congress rather than the Senate, and by simple majority vote. What do I mean by that? Well, think of NAFTA, think of the USMCA. These are international treaties where the Senate has not consented by a 2/3 majority, but Congress has consented by simple majorities. And once Congress consents by simple majorities, the president makes the treaties. This gives these treaties sort of a democratic stamp of sorts, but does so in a way that's inconsistent with the Constitution. The Constitution provides that the president can make treaties by and with the advice and consent of the Senate, 2/3 of the Senate, and now presidents are making treaties without 2/3 of the consent of the Senate, albeit with a majority of both chambers. And so this is an evasion of the treaty clause. You might think it's a good evasion. It might be seen as an improvement to have both chambers involved rather than just the Senate. And you might favor international agreements. And this makes it easier to conclude them, to make them with foreign nations. But this is clearly unconstitutional under the original Constitution. There is no authority under the original Constitution for a president to make a treaty with the majoritarian consent of both chambers. And in fact, many founders said the House has no agency in the making of treaties. There were disputes about what responsibilities the House had in the wake of a treaty, but no one believed that the House could sanction the making of a treaty, the ratification of a treaty by the United States, by the president. And then with respect to law execution, no one believes that the president is principally a law executor anymore. We're more apt to think of him as a policy innovator and as a host of other things rather than an executive officer. And why is that? Well, that's because presidents today run on a policy platform of innovation with respect to federal law and policy. And when they get into office, what are the first thing they do? They repeal a bunch of executive orders that are essentially interstitial law and put their own stamp on these executive laws. But they do far more than that, right? Congress has, of course, delegated tremendous amounts of authority to the executive branch, notwithstanding the non-delegation doctrine. The Chevron doctrine gives the executive branch further authority to make interstitial laws. But finally, and I think worst of all, presidents often misconstrue statutes in order to advance their policy goals, or in order to advance their re-election prospects, or to satisfy campaign promises. So let me give you some examples. In 2008, we had a financial crisis. George W. Bush wanted to bail out the automobile companies. All he got was a financial institution bailout. The House passed an auto bailout bill. The Senate did not. But George W. Bush decided to use the funds for the financial institutions for the automobile companies. Barack Obama continued the program. Now, you may agree with George W. Bush that the automobile companies needed to be bailed out, and you may disagree with those senators who refused to support it. My only point is that this was unconstitutional. It is unconstitutional for the president or anybody else to take money out of the Treasury without an appropriation, and there was no appropriation to bail out the automobile companies. Both presidents did it because they were afraid of the adverse economic consequences to GM and Chrysler going belly up. It's not just the debtors that are left holding the hook, or perhaps the shareholders that have their shares reduced to zero, or even the employees. It's all the ancillary companies that are also dependent on GM and Chrysler, the part suppliers, the finance companies perhaps, and all the mom and pop stores, right, in those communities. There would have been cataclysmic consequences, I think, possibly from these bankruptcies and those companies going under, and that's why he did it. But again, it was illegal. Let me give you another example, also having to do with appropriations. The ACA authorized, but did not appropriate funds for insurance company subsidies. The idea was we need to subsidize these companies in order to make it, to keep premiums low for new ACA coverees, insurees. So let's give these companies money, and they'll make sure the premiums are low for these new individuals who are signing up for Obamacare insurance. Well, the Obama administration went to Congress and said, please give us money so we can pay out these insurance company subsidies, and the Republicans said no. Realizing that no subsidy would be forthcoming and that the premiums would be sky high if there were no such subsidies, the Obama administration did a 180-degree turn and claimed that the statute appropriated funds, even though they had previously asked for an appropriation precisely because they knew it did not. And so they just manufactured an appropriation in order to prop up the ACA. This was litigated before a district court, and the district court found it to be unconstitutional, and the district court was clearly right. The Obama administration manufactured an appropriation in order to defend its landmark legislation. It was unconstitutional what it did, but it did so because it thought it had to. I can give you the example from this administration of the wall. John and I disagree about the constitutionality of the president's acts or the legality of the president's acts. There are, President Trump ran on the promise of building a wall. He was unable to get money from the Republicans. He got $1.5 billion from Nancy Pelosi, but that wasn't enough. And so he declared a public emergency and transferred funds from the Defense Department to the wall based on a statute that said that if he declared an emergency, he'd be able to transfer those funds. And the statute doesn't define what an emergency is, of course, but it boggles the mind that the president, on the same day he got $1.5 billion, declared this emergency, because there was nothing that changed from the time he signed the bill into law and the time he declared an emergency. There, of course, was no emergency at the border, at least not one that anyone would recognize an emergency. We have the same problem we perennially have, which is more people coming across the border and not enough resources allocated to stopping them or deporting them. That's not an emergency. That's just a long-term problem. He tried to solve it with his wall. He got some money. He didn't get as much as he wanted to, and he hit upon this expediency to find the money, to find extra money to keep his campaign promise. So this was a faux emergency. Unfortunately, it was a faux emergency of the sort that we've seen time and time again from many presidents. And I could give you other examples of the Obama and Trump administration misconstruing statutes to advance either re-election goals or policy preferences of the incumbents. This is remarkably common. Whenever statutes run up against the president's policy preferences or his campaign goals, the statutes lose, and the president's goals and always trump. So why do we come to this situation? The book identifies several reasons, but let me just identify two here. One is that Congress is a weakened institution. It is divided by party loyalties in a way that the founders didn't quite contemplate. Anywhere from 40, 50 to 60% of each chamber favors the president, sees the president as party leader, favors what the president is doing because it advances the party agenda. And when that's true, they're not going to criticize the president. If Biden does something that favors the left wing of his party, they're not going to criticize him, even if it's illegal. And if Trump does something that favors Republican orthodoxy, the Republicans aren't going to criticize him, even if it's illegal. Well, that weakness in Congress, that partisan weakness in Congress, has the effect of strengthening the president systematically. That's not something the founders really thought about. They didn't foresee the rise of political parties. The last thing I'll mention is the rise of the theory of the living constitution. If congressional powers can change with the times, that is to say, expand to deal with new sorts of issues and new perceptions of the need for national solutions, if the judiciary can expand certain rights, say due process, shrink other rights, say the contracts clause, why can't the presidency likewise expand as circumstances dictate or necessitate? And that's precisely the position that presidents have taken. Presidents believe, and their lawyers believe, that practice can put a gloss on the Constitution, and they use this sort of theory to justify the expansion of executive power. So there are progressives who are prone to criticizing the expansion of the presidency from time to time. See Arthur Schlesinger and his theory of the imperial presidency. But they're on the horns of a dilemma. If they really believe in a living constitution, what is so wrong about a living presidency? That's the title of my book, right? It's meant to stir the thought process in progressives and make them reconsider their adherence to the living constitution. On the other hand, if the founders' presidency is so great, as Schlesinger at times seemed to argue, why is the founders' Congress or the founders' conception of rights not so great, right? What is it about the presidency that it alone is supposed to be preserved in amber, but everything else around it can change in all sorts of weird and interesting ways? So that's the sort of mega claim of the book, and I really look forward to your questions. Thanks so much.
Thank you both so much for both of your lectures. I'll go ahead and get started with some questions. We have a good number. First one, could you speak a little bit, this is for each of you, about your thoughts about executive orders and how executive orders have shaped the presidency?
Cy and I have differing views on this. He mentioned the border wall. You can see a lot of executive orders are not actually claims of presidential constitutional power. They're examples where Congress has delegated enormous authority to the executive branch, and then the president makes findings that trigger those powers. With the border wall, for example, I just disagree with Cy. I think the National Emergencies Act doesn't define what an emergency is. Congress made that decision, and then they also made the decision to sprinkle throughout the law a great number of statutes that trigger powers on the part of the president, like the power to move money between military construction accounts and projects once there's a national emergency or a declaration or just a state of war. If Congress doesn't want the president to have that power, then it can easily change the standards under which a national emergency is defined, or change those other statutes. It's chosen not to. What's really going on, and I expect this is going to be equally true under a President Biden as it was under President Trump, is that Congress just doesn't want to take accountability for these kinds of decisions. They know these are hard decisions. They don't really want to take a firm stand on where to have the border wall and how to build it. So instead, they want the president to make those hard choices and then to take the political accountability for it. And I don't think that's going to change. So I expect fully that President Biden is going to use executive orders just as much as Donald Trump did, and just as much as Barack Obama and George W. Bush did, because Congress wants them to. Congress easily has the constitutional power of the purse to stop any of these things from happening. For example, take Cy's example of the border wall again. If the Congress really wanted to stop the border wall, all they got to do is attach a rider to any of these spending bills and just say no funding for any construction of any wall along the border. They know how to do it. They do it all the time when it suits them. They just choose not to. And so I expect, especially if Republicans keep the Senate, which I don't know, it seems to me that's probably more likely than not. All they have to do is win one out of the 2 Senate seats in Georgia. Then I think President Biden is really going to resort to executive orders, because he's going to be frustrated on any of the more extreme measures that he might want to take, because otherwise he's going to have to work with Mitch McConnell and the Republicans to get legislation through the Senate.
I agree with much of what John said. I think the Biden administration will find the Senate unhelpful in some respects, and will try to work around it through administrative action of various sorts, including executive orders. I understand, him to be taking up the mantle of Obama. Obama had the pen and phone strategy, which he used to basically circumvent Congress when he didn't like their recalcitrance. And John has talked about the power of presidents to reverse things, and I call it the eraser strategy. And so some Trump executive orders, he's going to try to work with Congress, but as soon as he finds that they aren't playing ball, he's just going to issue orders that he believes are legal, that reflect his priorities. And that's where the rubber meets the road, right? Because are these orders actually legal or not? And I think it's clear that over time, executive orders have, I think, been used to cover things that aren't contemplated in the statute. Not just the wall, but more generally. That is to say, they find areas where the statute is supposedly silent, and then use that silence to justify a slew of things. And I expect that to continue. The Biden administration is not going to be wedded to some narrow view of presidential power or narrow view of the scope of executive orders.
Great, thank you. Next question we've gotten a couple of questions about this one. Who has sufficient standing sorry about that, wrong question. Who has sufficient standing to challenge any constitutional usurpations by a president?
So the typical law student question, don't you guys care about anything important? You're asking a standing question? God, you guys just showing off. You guys took federal courts. So I think there's a political and then the legal distinction here about whether the court's going to address these questions. So legally, I think in a lot of cases they're standing if you believe that the court really enforces standing as a doctrine, a neutral doctrine. But I think politically they try to avoid these questions all the time. So take the dispute that Cy and I have about war powers. I don't think the declare war clause means authorize hostilities. I think elsewhere in the Constitution, for example, the text says that states shall not engage in war unless they receive the consent of Congress, which is sort of obviously the structure that they would have used if they wanted to adopt this sort of declare war idea that Congress has to go first. But I think it's without a doubt that if you're a soldier that's called up to serve in war, that you have standing to challenge the constitutionality of it. Yet the Supreme Court has never taken that case. Lower courts have all tried to hide from these, saying that there's no standing, or it's not ripe, or then later that it's moot. And I think the courts have tried to do that for the most part in the other foreign affairs questions that Cy has criticized the presidents for. For example, why can presidents resort to congressional executive agreements or sole executive agreements rather than treaties? The Supreme Court's never taken that question either. Has never shown any interest in taking that question, even though if you were, for example, a competitor, a business that just has a competing foreign rival whose entry into the US market is made easier because of NAFTA or the WTO, I think it would be clear you would have standing to challenge the legality of how the agreement was made. So I think it's more political, not a political in the sense of Republican, Democrat, but political in the sense of the court as an institution wanting to step away because they expect if Congress really wants to fight for its constitutional prerogatives, they should do it. They don't need the court to help them. I think that's true. And that the court's also worried that any decision it might make might get ignored by the president or Congress too if the stakes are high enough, as they often are in war.
I agree with much of what John said. And I think, John and I are really just talking about our views about the Constitution, independent of whether there's judicial review. So, John can be right whether or not there's judicial review. I could be right whether or not there's judicial review. But I also agree with him that there will be cases where people will have standing to challenge some of these things. With respect to the treaty point that John made, I'm not sure that someone has standing to challenge the making of an international agreement that has no domestic content to it in federal court, right? That is to say, suppose Trump makes a treaty of alliance with a foreign nation and doesn't go to the Senate. I don't know how anybody has standing to challenge the treaty because it doesn't create any legal rights or responsibilities that ordinary citizens have to honor. And that might be true for NAFTA and the USMCA, right? There are statutes that implement those agreements, and those statutes may or may not be constitutional, independent of whatever treaty is made on the international plane. So it's a smart question for someone to ask, given how and when the courts get involved, but it's not the only question that ought to be asked.
Thank you. We have another question. A couple last ones are more policy questions. Could you discuss the Paris Climate Accord and how that is affected by both of your thoughts on the subject?
I think the Paris Accords are interesting, and they evolved also with the last question: how do you challenge presidential what I would claim is usurpations of authority? And even in this case, I think there might be an interesting constitutional problem. So the Paris Climate Accords are, I guess, constitutionally, they're a sole executive agreement. Congress never ratified them. They've never even submitted to Congress any real form, either as a treaty or a congressional executive agreement. So the interesting question is, does the president have any domestic authority? See, I don't know if I think sole executive agreements are unconstitutional. I think they're perfectly constitutional if you view them as a president just promising to another country or here a multilateral set of countries to exercise his or her policies and constitutional authorities in line with the agreement. So they really, I think, only really last. They're just a promise that lasts as long as that president's in office. But the interesting thing is, and so I don't think, and this is my view of treaties also, and that's why I think there's also always a check on the presidents if they really are abusing these powers, is Congress really is the one that's in charge of whether they have any domestic force. Now, the interesting problem, I think, with the Paris Accords, which I take it that President Biden intends to, President Biden intends to sign on his re-enter on his first day of office, is suppose the EPA were to change, seriously ramp up the fuel efficiency for cars. Instead of the average mile per gallon for the fleet being, 30 miles per gallon, they say it's got to be 45 miles per gallon because we have to meet the schedule set out for pollution reductions that we agreed to in the Paris Accords. That might, certainly that would be something that could be challenged, I think. Right? A car manufacturer could say, well, this is an agreement that the president signed, but it has no domestic force. Why can it be used as a justification by the EPA to change a regulation to a standard that otherwise it would not have been able to adopt based on the science and policies when you just look at the United States? I think that would be actually a way one could challenge that. And then this is a policy matter. I just think the Paris Accords are a terrible idea. That's why when I wrote the book with Jeremy Radkin, it was about international law and policy. I don't see how an agreement without any enforcement mechanism to stop China or in India, the growing major polluters in the country or in the world is really going to have any effect on global warming. In fact, the United States will not, even though the Trump administration pulled out of the agreement, the United States has dramatically cut its pollution, but that's because it was just more efficient in the markets to change to natural gas away from coal generation for electricity. So I expect that the United States is going to be able to take care of its own reductions of pollution because that's what the American people want, and we're a sovereign nation and we have control over our own territory and borders with our own system of laws. But I don't see how the Paris Accords is going to possibly get other countries to cut pollution unless it's already in their self-interest.
So the dividing line between executive agreements, sole executive agreements, and treaties is uncertain, but I think it's there. The distinction is founded in the Constitution itself. Article 1, Section 10 talks about states not being able to make treaties, but able to make compacts if Congress agrees to the making of those compacts. And when you move to Article 2, it says the president can make treaties by and with the advice and consent of the Senate. And John and I both believe that the president can make compacts without going to the Senate. But the question is, how do you distinguish compacts from treaties? And Mike Ramsey and others have suggested that there are various indicia that render certain international agreements less important, less long-term, and therefore more compact-like and less treaty-like. Now that dividing line isn't obvious, but we know that presidents made compacts outside of the treaty clause, several dozen of them in the first 50 years or so. My claim is that category of compacts or sole executive agreements has expanded over time in an unconstitutional way to cover the sorts of things that wouldn't have been done by treaty, that would have been done by treaty in the past. So for instance, I don't think the president can tell a foreign country, we will come to your defense and sign an agreement to that effect. That is basically a treaty of alliance. We know that there were such treaties because we signed them, right, prior to the Constitution and afterwards. That is just a promise, like all contracts are, but it is a significant promise. And before the president makes that on behalf of the United States, he has to go through this process in the Senate. He can't use the category of sole executive agreements or compacts to make that sort of claim. And so, again, the question is what divides compacts from treaties? That's a difficult question, but some things are clearly on one side versus the other. A commercial agreement is likewise a treaty. How do we know this? Because we had commercial treaties. right, in the 18th century that we made that went through the Senate process, and in the 19th century. The Paris Climate Accords are weird because they're part sole executive agreement, they're part political commitment. I think maybe John's right that someone could challenge a agency that cited the Paris Climate Accords as reason for doing something or another thing. But that would turn on whether citing the Paris Climate Accords is itself necessary to do the thing in question. And so the EPA might always say we have authority under the existing statutes to change particulate emissions. We don't need the Paris Climate Accord. And if they're successful in making that claim, then the Paris Climate Accord won't matter to the adjudication of that claim.
Thank you. We have one more time for one more question. Could you speak a little bit about if there's any president that you both agree on did not overstep his power, and could you talk a little bit about his presidency?
I think Cy thinks it's from George Washington on. Everyone's been a terrible violator of the Constitution, except maybe for James Buchanan, the worst president in American history, who did not use executive power to try to stop the Civil War. This is also a hard question. I think every president, let's just take the 20th century, because I think in the 20th century and the 21st century, I think Cy would say most presidents have been violators of the Constitution in his model, except maybe Calvin Coolidge. People often say Calvin Coolidge was a president who tried to restrict and actually narrow the size of the federal government, and often would say things about how, I believe he often, I looked at a biography as of a few years ago. There was an excellent one done. Would say things that, oh, that's outside the power of the federal government or the power of the president. But there's the dynamic at work really stands against us. Cy, I think, tends to think this is almost unconstitutional. I think it's rather natural, which is that presidents have this incentive to try to push the boundaries of their power, to have a unified agenda, to make campaign promises, to try to live up to them, because they are elected, just like all other politicians in the system do the same thing. They all, members of Congress and members of state executives, they also do things like make promises and try to stick to an agenda and keep them because they want to be reelected. I don't think that the founders had a view of the presidency that set it really aside from the rules of normal politics. In fact, Alexander Hamilton, when they designed the original presidency, they didn't put term limits on it. Because they thought the prospect of reelection was sufficiently important that itself would also be a check on the presidency, because they expected presidents would want to get reelected, and that part of their reelection would be based on whether they had achieved their agenda and whether they kept their promises, and whether ultimately they had enforced the laws, protected the national security, and observed the Constitution. But I think sometimes Cy's vision of the presidency, it sounds to me almost ministerial. Sometimes I like to tease him. I say he has the HR view of the presidency. The president is just in charge of human relations department of the government. And that's really up to Congress to give the president the powers and the responsibilities. Otherwise, he's just in charge of hiring and firing the people who shuffle the papers around. And I think the presidency is much more than that. I think Hamilton's vision was a president would be someone of energy in the executive who could react to unforeseen events. They would be the active part of government, and that the framers would review what he or she had done. And Congress, if they don't like it, they can fight back. Ultimately, they can impeach him if they think he's or she's been abusive in their powers. But that it really isn't, I think, this kind of, I think of it as a very kind of cabin view of the executive that Cy's promoting.
So this is a debate between two proponents of an energetic executive. John just believes in a more energetic executive than I do. And I actually think my view is the Hamiltonian approach, not John's. It's Hamilton that says that the president can't start a war. It's John who says he can. It's Hamilton who says the president lacks emergency authorities. John thinks the president has them. So I don't have the HR view, but guess what? We're going to have a president who does have the HR view of diversity, and we're all going to get diversity training very soon from President Biden. So John and I agree on so much with respect to the presidency. We just disagree with certain features of it, right? with respect to war powers, with respect to emergency powers. I think with respect to the idea, is the executive power fixed in the 18th century, or does it float over time? John, I think, clearly thinks it was meant to bloom and grow forever, to quote Edelweiss from The Sound of Music. I don't think so. I think there was a set list of powers associated with the branch that future presidents couldn't add on to. To answer the precise question of the listener, though, is were there presidents who basically honored the original Constitution? I'd say, yeah, for the first century or so, that was the original. That's what presidents did, right? You don't see these presidents really bastardizing statutes to achieve policy aims. They're much more, I want you to do this. If you don't, I guess I can't do it, right? And they don't assume emergency powers. Washington certainly doesn't, and others don't as well. The one exception is the great Abraham Lincoln, right? Abraham Lincoln takes a number of steps during the Civil War, each of them justifiable on policy grounds, but not all of them constitutional. And he himself recognizes this. If you read his 1861 speech to Congress, he distinguishes some acts from others. He distinguishes habeas corpus. With respect to that, he does think he can suspend habeas corpus. With respect to increasing the size of the army and expending funds without an appropriation, he basically says, I didn't do anything that you couldn't do, which is essentially saying I did something that I shouldn't have done, but I had justification for it. And he hopes that Congress might take up legislation to ratify those measures. And I'll add that, Lincoln was a Whig, so he actually had a narrow view of presidential power until he got into office and he faced the Civil War. And maybe that's John's sort of more general point, right? That, when faced with a crisis, presidents will often do that which they think is necessary, the Constitution and laws be damned, and that we ought to reconceptualize our understanding of the Constitution and laws in light of this to regularize and legalize this. My view, as he would put it, is a Jeffersonian view, which is sometimes the president's got to act illegally to save the nation, but we shouldn't misunderstand what's going on and describe that as legal. It's actually illegal, but good, as opposed to whatever is good policy is necessarily legal and constitutional.
All right, that concludes our event. Thank you so much for both of your time. We really appreciate that you took the time out to visit us at George Mason. I do want to also thank everyone else who came to this event. This is our last event of the semester. Really great send-off for us. So we'll be happy to see you all again in the spring. And again, thank you to Professor Prakash and to Professor Yu for joining us today.
Thanks, guys.
Thanks, Sydney. Thanks, Sai.